Welcome to American Justice 21, only on the USA EBN Digital Broadcasting Network. This video explores the broken promise of equal justice under law and how America's public defense crisis undermines the Constitution. In 1963, the Supreme Court guaranteed every person accused of a crime the right to an attorney, declaring it fundamental and essential to fairness. Clarence Earl Gideon was denied a lawyer in Florida, represented himself, and was convicted and imprisoned. From prison, Gideon handwrote a petition arguing that the Constitution entitled him to an attorney. The Supreme Court unanimously agreed in 1963. The court ruled that without a lawyer, the right to a fair trial is meaningless, establishing that states must provide attorneys for indigent defendants. When retried with a court-appointed attorney who effectively cross-examined witnesses, Gideon was acquitted in about an hour. Today, 60 to 80% of state felony cases and 90% of federal felony cases are handled by public defenders. Public defenders manage hundreds of cases yearly, lacking time and resources for quality representation. 1 in 3 Americans will have a criminal record, making this a widespread issue. Defense quality depends on financial means, not case merits, undermining equal justice. Missouri caseloads are 225% above recommended levels, and Oregon needs 31% more defenders. Traditional 1973 standards recommend a maximum of 150 felony cases and 400 misdemeanor cases per attorney annually. New 2023 research shows these standards are dangerously inadequate for modern practice. Murder cases require 248 hours on average, meaning defenders can handle only 8 per year. Harris County, Texas manages 6,540 active cases with just 82 defenders. $116 million in supplemental funding is needed to pay federal panel attorneys in 2025. In July 2025, the federal system ran out of funds to pay court-appointed lawyers. Over 12,000 private panel attorneys are affected nationwide, facing a 3-month payment delay for constitutionally mandated work. Panel attorneys represent over 90% of federal criminal defendants and are mostly solo practitioners or small business owners. 97% of federal cases are resolved by guilty pleas, and 90 to 95% of state cases are resolved through plea bargaining. In Texas, New York, and Pennsylvania, less than 3% of cases go to trial. Excessive workloads force attorneys to reduce client communication and conduct inadequate investigation. Defenders cannot effectively challenge prosecution evidence, leaving constitutional violations unchecked. Trial numbers fell dramatically, even as case volumes rose. Some counties had no trials for years. Handling 200-plus cases yearly makes thorough case investigation nearly impossible. Overburdened defenders cannot secure timely release for clients, leading to extended pretrial detention for people who have not been convicted. Defendants with public defenders are more likely to be detained pretrial than those with private counsel. Pretrial detention increases conviction likelihood and sentence severity as detained defendants accept unfavorable pleas. Over 400,000 people in the U.S. are detained pretrial, still legally innocent, many jailed because they cannot afford bail. Detained defendants often lose employment, residential stability, and parental rights while awaiting case resolution. Higher conviction rates and longer sentences are seen for detained defendants versus those released. Excessive caseloads constitute a constructive denial of the right to counsel, as attorneys cannot provide representation that meets objective standards of reasonableness. Innocent people plead guilty to get out of jail when they cannot afford bail and face extended pretrial detention without adequate legal representation. Studies show detained defendants receive longer incarceration terms and engage in higher levels of future criminal activity than those on pretrial release. Public defenders cite low pay and severe workload as top reasons for resigning, with mass departures from leading agencies undermining the practical guarantees of the Sixth Amendment. U.S. Attorney General Eric Holder described America's indigent defense systems as existing in a state of crisis and called for all levels of government to address this injustice. The scarcity of qualified public defenders puts additional strain on remaining lawyers, further contributing to excessive caseloads and a devastating feedback loop. The annual national cost of pretrial detention alone exceeds $13.6 billion, much of it resulting from inadequate legal representation. Plea bargaining saves courts $1.2 billion annually, but this efficiency sacrifices constitutional rights and just outcomes. Wrongful convictions lead to expensive settlements and appeals, while jail crowding requires costly facility expansions. When defenders are punished for refusing unconstitutional workloads, the right to counsel becomes nominal only. A two-tiered system means justice quality depends on financial means, resulting in a constitutional crisis where the right to counsel exists in name only for many. 60 years later, Gideon's promise remains unfulfilled. The public defender system was established in 1963 to ensure equal justice. But despite legal standards guaranteeing competent representation, defenders remain under immense strain. Lack of sympathy for the accused, skepticism toward the presumption of innocence, and underlying systemic racism allow the crisis to persist despite overwhelming public support for reform. Quality of legal defense depends on financial means, creating a justice system where poverty dictates outcomes rather than the facts of the case or applicable law. 50 years after Gideon, this right has not been realized as prosecutors possess broad, unchecked power, and governments have failed to adequately fund defense systems. Understanding the constitutional promise and why it remains broken. The right to counsel is fundamental and essential to fairness. Yet 60 years later, Gideon's promise remains unfulfilled for millions of defendants across America. The Supreme Court guaranteed the right to an attorney for those who cannot afford one in 1963. Public defenders handle 60 to 80% of state felony cases and 90% of federal felony cases. Clarence Earl Gideon was denied a lawyer in Florida, represented himself, and was convicted despite weak evidence. From prison, Gideon petitioned the Supreme Court, which unanimously agreed states must provide counsel. The court ruled lawyers in criminal courts are necessities, not luxuries, for a fair trial. When retried with counsel, Gideon was acquitted in an hour, proving the power of representation. Defenders manage hundreds of cases yearly, lacking resources for quality representation. Missouri caseloads exceed 225% above recommended levels, creating impossible situations. Oregon needs 31% more defenders as jurisdictions operate with critical staffing shortages. Structural failure stems from bare minimum models, relying on county budgets or part-time attorneys. Traditional 1973 standards recommend a maximum of 150 felony and 400 misdemeanor cases per attorney annually, but 2023 research shows these are dangerously inadequate. Murder cases require 248 hours on average, meaning defenders handle only 8 per year, yet many carry far more complex cases simultaneously. Harris County, Texas manages 6,540 active cases with just 82 defenders, creating an impossible 80-to-1 ratio that makes meaningful representation nearly impossible. When attorneys carry unmanageable caseloads, investigations are rushed or skipped, client contact time collapses, and motions are filed late or not at all. $116 million in supplemental funding is needed to pay federal panel attorneys in 2025. Over 12,000 private panel attorneys are affected by the funding crisis nationwide, facing a 3-month payment delay for constitutionally mandated work. 90% of federal criminal defendants are represented by underfunded panel attorneys. Panel attorneys represent over 90% of federal criminal defendants and are predominantly solo practitioners or small business owners who uphold the constitutional right to counsel. State versus county funding creates vast resource disparities. Fee-based funding means fines, and fees from defendants fund their own defenders. State-funded systems in Colorado and Massachusetts show lower caseloads and higher trial quality, while county-funded rural systems lack tax bases. Fee-based funding through traffic tickets and court fees creates perverse incentives, violating the spirit of Gideon. Many public defender offices operate without investigators or expert witness budgets, forcing attorneys to handle complex cases without essential support. Growth in law enforcement spending has far outpaced indigent defense spending, leaving public defenders without resources to protect clients. Hallway justice is common, with many defendants meeting counsel only briefly before major decisions. Time and resource constraints prevent proper case investigation, and missing resources mean no investigators, experts, mitigation specialists, or modern case management. Public defenders face crushing caseloads, making it normal for a single defender to handle 400-plus misdemeanors or 150 to 300 felonies yearly, violating every professional standard. Attorneys skip investigations because there is simply no time, and clients sit for months in jail before counsel can even review discovery. Many defendants meet their attorney only briefly, often in rushed hallway conversations moments before major decisions must be made under immense pressure. The imbalance is stark. Prosecutors have access to full police reports, witness statements, digital evidence, and lab results, while defendants often see only summaries or partial disclosures. Excessive workloads force attorneys to reduce client communication and conduct inadequate investigation, leaving constitutional violations unchecked. Defenders cannot challenge prosecution evidence, and handling 200-plus cases yearly makes investigation nearly impossible. Trial numbers fell dramatically, even as case volumes rose, with some counties having no trials for years. Plea bargaining saves courts $1.2 billion annually, but sacrifices constitutional rights and just outcomes. Defendants with public defenders are more likely to be detained pre-trial than those with private counsel, creating a wealth-based detention system. Over 400,000 people in the U.S. are detained pre-trial, still legally innocent, with many jailed because they cannot afford bail. Pre-trial detention increases conviction likelihood and sentence severity, as detained defendants accept unfavorable pleas to escape jail. Detained defendants often lose employment, residential stability, and parental rights while awaiting case resolution, creating cascading family and community harm. Higher conviction rates are seen for detained defendants versus released defendants. Longer sentences are given to those who cannot afford bail. The U.S. Attorney General described indigent defense as being in a state of crisis. Innocent people plead guilty to escape jail when unable to afford bail or secure adequate legal representation. Detained defendants receive longer sentences and show higher future criminal activity than released defendants. Low pay and severe workload drive mass departures, undermining Sixth Amendment guarantees. U.S. Attorney General Eric Holder called the crisis a fundamental injustice requiring action at all government levels. Annual pretrial detention costs exceed $13.6 billion, resulting from inadequate legal representation. Wrongful convictions cause expensive settlements, while jail crowding requires costly facility expansions. Punishing defenders for refusing unconstitutional workloads creates legal liability for jurisdictions. Investment in defense reduces long-term correction spending and appeals litigation costs. Politicians ignore indigent defense because it is politically safer to fund law enforcement, while poor defendants have little lobbying power. Tough-on-crime political incentives overshadow constitutional obligations. Poor defendants lack lobbying power and political influence. Legislatures fail their constitutional duty to fund defense. Many politicians champion law and order, but the Constitution requires equally rigorous defense. Legislatures that refuse adequate funding violate constitutional obligations. Tough-on-crime promises overshadow constitutional obligations, making it politically safer to fund prosecution than defense, despite equal importance. Elected officials are employees of the American people, yet many remain delinquent in their constitutional duty. Lack of sympathy for the accused, skepticism toward presumption of innocence, and systemic racism allow the crisis to persist despite public support for reform. County-based systems in rural areas cannot afford full-time public defender offices. Contract attorneys paid per case incentivize speed, not quality. Rural regions fund defense through county budgets with smaller tax bases, unable to afford full-time offices. Contract models incentivize speed, not quality, creating financial pressure to resolve quickly through pleas. Counties with part-time contract attorneys lack investigators, expert witness budgets, and modern technology. Rural defendants face attorneys covering multiple counties, leading to delays and reduced access. Spending growth for law enforcement far exceeds defense spending. Prosecutors have investigators, experts, and labs, while defenders do not. In New Orleans, public defender funding increased from 35% to 85% of what's given to the district attorney's office. Growth in law enforcement spending has far outpaced indigent defense. Even progressive prosecutors have fought attempts to remedy budget discrepancies. A better-funded indigent defense system could act as a more vigorous check on prosecutorial power, ensuring fairer results through meaningful adversarial process. State-level centralized funding eliminates county disparities and ensures consistent resource allocation. Mandatory caseload caps prevent burnout, ensuring attorneys meet objective standards of reasonableness. Counsel at first appearance reduces pretrial detention and protects rights during critical bail hearings. Independent oversight boards prevent political interference, ensuring funding prioritizes constitutional rights. Investment in investigators and expert witnesses gives defenders equal access to prosecution tools. Public defense funded at parity with prosecution creates a truly adversarial system for fair cases. Understanding the reforms that ensure justice for all. Modern standards require 286 hours for high-severity felony defense, compared to the outdated 1973 standard of 150 felony cases per attorney per year. Today, 35 hours are needed per felony case, but 1973 guidelines allowed only 13.9 hours. Modern criminal defense involves body camera footage, digital evidence, forensic analysis, and social media data. Complexities that didn't exist when current caseload standards were set over 50 years ago. Track cases using modern weighted standards that account for case complexity and required time. Implement formal protocols to refuse new cases when caseloads exceed constitutional thresholds. enable attorneys to provide competent representation according to prevailing professional norms. Near-term action. Enforce caseload caps to prevent case overload and protect both attorneys and clients from constitutional harms caused by excessive workloads. Excessive caseloads force attorneys into triage mode, where many cases are resolved without appropriate investigation or preparation. Overburdened defenders cannot conduct thorough investigations, review discovery materials, or adequately communicate with clients. Workload limits must be based on rigorous research and implemented with clear deadlines. Defenders carrying more than 150 felonies yearly average only 13.9 hours per case, far below the 35 hours minimum needed. The typical time frame for first appearance after arrest is 48 hours. Access to counsel increases pretrial release rates. First appearance determines jail or home, affecting jobs, housing, and family stability. Without counsel, defendants face unaffordable bail and extended detention. Attorneys present mitigating information and ensure constitutional protections from day one. Early representation improves case preparation and helps defendants understand their rights. Retention pay and workload triage prevent experienced attorneys from leaving public defense due to unsustainable conditions. Supervision and training ensure defenders stay current with evolving laws and digital evidence practices. Excessive workloads disproportionately harm people of color, creating systemic inequities in representation quality. Competitive compensation and manageable caseloads are essential to recruiting skilled attorneys committed to constitutional defense. Investigators, experts, mitigation specialists, and interpreters transform defense from symbolic to substantive. Investigators are essential for fact-finding and case preparation. Expert witnesses are required for forensic and technical testimony. Mitigation specialists are critical for sentencing advocacy. Investigators conduct factual investigation to challenge prosecution evidence, locate witnesses, and uncover exculpatory information. Expert witnesses provide testimony on forensic evidence, mental health, ballistics, and digital forensics crucial to defense. Mitigation specialists gather social history and contextual information essential for sentencing advocacy. A California study found inadequate investigation was a consequence of excessive workloads and limited support staff. County-based funding creates wealth-driven disparities where poor counties cannot afford adequate defense while wealthy counties can. State constitutional obligation to provide counsel should come with state financial responsibility to ensure uniform quality statewide. Centralized funding allows for economies of scale, consistent compensation standards, and strategic resource allocation across jurisdictions. 16 states have established statewide defender programs or oversight commissions to ensure quality and accountability. Independent commissions are insulated from political and judicial pressure. Case management systems are critical for tracking and efficiency. Independent oversight commissions monitor performance, enforce standards, and measure outcomes without political interference. Commission members should include defense practitioners, formerly incarcerated individuals, and community stakeholders to ensure accountability. Modern case management systems digitize records, automate scheduling, and reduce manual data entry by up to 85%. Digital evidence platforms help attorneys organize body camera footage, surveillance video, and forensic data efficiently. Caseload thresholds must determine maximum cases per attorney by type and implement intake pause protocols when limits are reached. Baseline funding levels should calculate resources needed to meet constitutional standards and commit sustainable budgets for staffing and support. Oversight authority should establish independent bodies with power to measure compliance, enforce standards, and require system improvements. Caseload thresholds must reflect modern workload research showing 35 hours average needed per felony case, not outdated 1973 estimates. Funding decisions should aim for prosecutorial parity, ensuring defense has comparable resources. Oversight bodies need authority to collect data, conduct audits, and mandate corrective action when systems fail constitutional requirements. Leadership must commit to multi-year implementation timelines with measurable benchmarks and accountability. 4 key indicators demonstrate whether reforms are working to ensure effective representation for every client. Caseload compliance at or below national standards with earlier attorney-client contact. Reduced pretrial detention and fewer continuances, maintaining jobs and family stability. Higher investigative activity shown by more motions filed, suppression hearings, and trial readiness. And lower appellate reversal rates on ineffective assistance claims, showing quality representation that meets constitutional standards. Closing the gap between the constitutional promise and practice. 90% of federal defendants require public defense, and 60% of inmates are awaiting trial without conviction. Gideon versus Wainwright established legal representation as a fundamental right essential to fair trials. Despite this landmark ruling, 9 states routinely violate the constitutional right to counsel. 1973 standards treat burglary the same as homicide, despite vastly different resource requirements. Public defenders face conditions making constitutional compliance nearly impossible. A 2023 national study found that 1973 caseload standards substantially overstate the work that can be performed according to modern professional norms. A 2022 American Bar Association report found that funding would have to increase threefold to meet constitutional standards. If new workload standards were followed, most public defender offices would need to double in size. Only 27% of county-based and 21% of state-based offices have enough attorneys to adequately handle caseloads. $116 million in supplemental funding is needed to prevent crisis. Over 12,000 panel attorneys accept assignments annually. A 3-month payment delay began July 3, 2025. The panel attorney program ran out of funds July 3, 2025, suspending payments to attorneys until October 1. Panel attorneys handle 40% of federal cases, often as the only counsel in rural jurisdictions. Unpaid attorneys are forced to withdraw, leaving defendants unrepresented and detained without counsel. A continuing resolution froze funding at fiscal 2024 levels, causing a cycle of panel attorney insolvency. Wrongful convictions with investigative failures account for 80.6% of 366 cases analyzed. The pretrial jail population increased 433% between 1970 and 2011, primarily due to judges setting unaffordable cash bail amounts. People without financial means remain in jail prior to trial because they cannot afford bail, resulting in higher conviction rates and lost employment. Wealthy defendants can afford extensive legal teams and expert witnesses, while poor defendants struggle with inadequate defense. Taxpayers spend $14 billion yearly to incarcerate legally innocent people awaiting trial. Incarceration causes $111 billion in lost annual income, plus $215 billion lost by children of incarcerated parents during their working years. Wrongful convictions undermine public trust and require costly litigation to correct. Functioning indigent defense prevents these costs by ensuring accurate outcomes from the outset. Increase public defense budgets threefold to meet constitutional standards and ensure adequate resources for investigators, experts, and support staff. Implement evidence-based workload limits based on rigorous research to ensure defenders can provide constitutionally adequate representation to each client. Establish state oversight with clear accountability, enabling public defenders to refuse cases when workloads become excessive and violate professional standards. Public defense workloads must be reasonable, ensuring counsel represents each client according to professional norms required by the Constitution. Workload limits should be based on rigorous research, like the 2023 National Public Defense Workload Study, implemented with clear deadlines. States must create oversight mechanisms to ensure constitutional obligations, as some currently lack data on unrepresented defendants. Treating public defense as constitutional infrastructure means recognizing it as mandatory for justice system integrity, not discretionary spending.